Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the healthcare lawyers at Epstein, Becker, Green, a leading law firm that has more than 40 years' experience serving clients in the healthcare industry nationwide.
Today on Diagnosing Healthcare, we discuss the No Surprises Act to provide an overview of the independent dispute resolution process and the external review process. Hello and welcome. This is Alexis Boaz hosting an episode of Diagnosing Healthcare. I'm an attorney in Epstein, Becker, Green's healthcare and life sciences practice based out of our Washington, D.C. office. As many stakeholders in the healthcare industry and policy world know, the No Surprises Act, or the NSA, as we'll refer to it today, which was enacted on December 27th, 2020, will go into effect on January 1st, 2022. We previously recorded a Diagnosing Healthcare episode on the first interim final rule, where we gave an overview of the No Surprises Act. However, the federal government has since issued additional interim final rules and guidance to implement the No Surprises Act, including the second interim final rule with requests for comment. In addition to describing how the NSA interacts with planned external review procedures, the second IFR describes the independent dispute resolution, or IDR, process and how the IDR's determination is made. This part of the regulation has particularly stirred up attention from stakeholders. Regardless, the bulk of the NSA, including the IDR process, will go into effect on January 1st. On today's show, we're going to provide an overview of the NSA's independent dispute resolution process and the external review process to highlight issues providers, facilities, plans, and other stakeholders might consider as they attempt to implement the law's various requirements. If you like what you hear today, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts. Today, Helaine Fingold and Lesley Yeung are joining our discussion. Helaine Fingold is a member of Epstein, Becker, Green in the Baltimore office. She has had significant previous experience within the U.S. Department of Health and Human Services, and now, in addition to advising many other types of clients, has been spending a great deal of time delving into the No Surprises Act to help clients in the health plan industry understand and comply with its requirements. Lesley Yeung, a member of Epstein, Becker, Green in the Washington, D.C. office, is also joining us. Through her practice and her prior experience at HHS as a program analyst and as a health insurance specialist at the Centers for Medicare and Medicaid Services, Lesley has similarly built a wealth of knowledge that she uses to advise many types of healthcare clients. Lesley has also done deep dives into the No Surprises Act and has been working with a variety of clients to address various NSA issues. Welcome, and thank you both for joining.
Thank you, Alexis.
Thank you. To kick things off, I'll give an overview of the payment process under the No Surprises Act. Once the No Surprises Act is triggered, and that's for situations when an item or service is furnished either by an out-of-network provider at an in-network facility or by an out-of-network emergency facility, and the law applies to the plan type and to the service type, the NSA protections apply to all items and services furnished during that visit. Once the items and services are furnished, the provider is no longer allowed to bill the patient directly under the NSA. The provider will have to send the bill directly to the plan, and this removes the patient from the process. In addition, the NSA sets the cost-sharing amount that is not tied to the payment that the provider or facility will ultimately receive from the plan. Let's stay with Helaine for a bit and go through the entire claims payment and IDR process. And then we'll turn to Lesley to learn more about the IDR entities and the NSA's changes on the external review process. Helaine, I provided a high-level overview of the NSA's payment process. Once the provider or facility determines the NSA applies to the out-of-network items or services, could you briefly discuss when the NSA would be used to determine the out-of-network provider or facility's payment amount?
So as you said, Alexis, it's really a process. It really defines how the parties interact with respect to the payment amount and the cost sharing. So the out-of-network provider or facility that provides a covered service, so an emergency or non-emergency service at the facilities that you described. So it's got to sort of check off all the boxes. They would send their bill, the claim, to the plan, and then the plan comes back and is supposed to provide either a denial or what's called an initial payment. You know, that doesn't sound like a technical term, but that's the phrase used in the law. The thing is it's not a defined term. So the plan can send whatever amount they choose And then the provider has the opportunity to accept the amount or to, I guess, reject the amount by saying, no, I want to negotiate. Under the law, really, both parties have the opportunity to ask for negotiation. We've talked a lot internally. We're not sure why a plan would move for negotiation at that point, but it's allowed for. And that's really how the process starts. But the NSA, and I think we're going to talk about this further, talks about once you've gotten into negotiation and head into the IDR, the independent dispute resolution process, it defines the factors and information and way that the dispute resolution entity looks at the amounts that have been offered to decide who wins, whose offer is chosen, and whether it's the provider and what they're saying, the provider facility, they should get paid, or whether it's the plan and it's the plan's amount that the plan says should get paid.
Great. And so when determining the out-of-network payment amount to the provider, as you mentioned, it's sort of a process to determine, if the state law applies, if the NSA applies, but there's a process for that, but then also a process to determine cost sharing that's similar, where the provider would have to assess if the state law applies or the NSA applies. The NSA requires cost sharing to be calculated using the recognized amount if it applies. Could you describe what the recognized amount is?
So these are another of the kind of terms, specific terms that the law uses that, gives them some relevance, I guess, to the calculation. But what it effectively is under the law says that they're trying to separate out the cost sharing as applied to the patient, the enrollee, from the payment dispute. Should there be a dispute, the payment transaction between the plan and the provider or facility. So what they're doing is they're saying that there are three potential sources for determining what the recognized amount is, quote, and that's effectively the amount that we're saying is the cost of the service, and to calculate what the patient's cost sharing will be. And those look to state law, two sources of state law, or federal law. It would look to state law if the state has what's called an all-payer system, which is a program under Section 1115A of the Social Security Act that gets approved, whereby a state is able to, as it says, do an all-payer system. The ones that are most probably people are familiar with, the one, exactly, probably only one, which is Maryland, has an all-payer system for hospital services that includes all payer, as it says, all payers. It's allowed to include Medicare because of the waiver, and it includes Medicaid, and it includes commercial. You would look to those rates for those services under that. Pennsylvania and Vermont also have all-payer systems, similarly narrow in what services are included, and the Pennsylvania one is even narrow in the geography that it applies to. But where those are effective, those would be set the recognized amount for calculating cost sharing. For the states that do not have the state all-payer systems, you would look to see if the state has what they're calling, again, under the law, a specified state law. And that's a state with a surprise billing law that has a mechanism for setting the payment amount. And the regulators, the departments working on this at the federal level, have not yet explicitly identified the states that they consider to have a specified state law. They've kind of intimated, they've said there are 14. They've cross-referenced some research that was published by the Commonwealth Fund that identify different states, the level of complexity of certain states' surprise billing laws. So we're kind of using that as our guide, but the government hasn't said. So where there's a specified state law, the specified state law would apply. Where there's no all-payer system, where there's no specified state law, or the specified state law that exists doesn't apply, then you look to the No Surprises Act, which calls for use of the qualifying payment amount. So again, more terminology to learn and to keep in your head. The qualifying payment amount, or QPA, is essentially the median contracted rate that the plan is paying for the same or similar service in the same market. So, large group, small group, self-insured, in the same geographic area for the same or similar type of provider or facility. The plan is looking to what their rates are in network and kind of saying, okay, here's what our median is. Here's what we pay across our plans in this network, in this market. That's what you're going to calculate the cost sharing against. And QPA is relevant, qualifying payment amount, as we move forward. That was kind of a long-winded way of saying, but it is a little complicated, and that's kind of sets out the tone for figuring out the rest of all these pieces of the No Surprises Act.
Great. Thanks, Helaine. As you mentioned, the QPA is a really significant data point for both cost sharing determination and the out-of-network payment amount determination under the NSA. Let's go back to the payment process. Ultimately, the plan must directly pay the non-participating provider the total plan or coverage payment at the out-of-network rate, not accounting for the initial payment amount and any allowable cost sharing amount. The NSA's out-of-network rate will ultimately be the amount agreed upon between the parties or as determined through the IDR process. So we can dive into that now. Helaine, could you describe the start of the payment process and how the parties may reach the negotiation state?
Well, I think it's kind of follows from where I started. I think I started in a little bit in one of my prior responses where, again, the out-of-network provider provides the service to the covered individual and then would get a response back from the plan, either an initial payment or a denial. And then that provider could reject whatever payment comes and say, no, I'm not satisfied with that. And they can move to enter negotiation. There's a process defined in the regulations in the second IFR that defines kind of how do you notify the other party, what's the process, what information you need to include to enter into negotiation. The negotiation process is a 30 business day time frame. So you have 30 business days to reach agreement before you can move into the next step, which is the IDR process. So if you can continue, in reality, you can actually continue to negotiate as you move into IDR, and until the IDR entity renders a decision, the parties can continue to negotiate. But to go to IDR, you have to exhaust that 30 business day period for negotiation. Those are, generally speaking, the rules. Again, if you are in a state or you have claims that are covered by state law or an all-payer system, you can't go through the federal negotiation and IDR process. Once it's determined that state law applies, again, then you are restricted in that you can only use whatever dispute resolution process the state provides for. And if there is none, you still have to figure it out under state law. It's not something you can use the federal process for.
Thank you. And along those lines, could you also describe any additional restrictions to entering into the IDR process?
You have to notify the party who moves is seeking to enter IDR has to have a note. There's a notification process and information they have to provide to the other party, but they also have to notify HHS, the Department of Health and Human Services, that they are moving to enter into IDR. HHS has set up a federal portal that will kind of govern and manage the IDR process that parties will use to notify the government and also to select the dispute resolution entity and kind of file any materials they want to submit. That all goes through the process. So those are the provisions for moving forward. I think the other restrictions, as I think through it, it's really about whether the services are appropriately under the No Surprises Act. That is something that the parties are supposed to establish, but the IDR entity is also tasked with ensuring that the cases that come before that individual are appropriately at the federal level. So that IDR entity is going to have to do the analysis to establish that the services under question there were not covered, should not be under a specified state law or covered by an all payer state system. Those are kind of the baseline pieces. One thing to note, and that I know, unlike some state surprise billing schemes or approaches where there is a minimum threshold to appeal, the federal NSA doesn't apply a threshold. So the parties can appeal a claim regardless of amount. And there's also under the law, there is something called the notice and consent process, which would also exclude the claim from the appeals, the negotiation and appeals process. And that is when, for non-emergency services, a provider can provide information to the patient about the fact that it's an out-of-network claim. There's several pieces of information to provide, essentially making sure the individual understands that this is out of network, that there's a financial level that they will owe that is in excess of what their in-network cost sharing is. And they can ask the person, and if the person willingly concedes and acknowledges, consents to the treatment at that out-of-network rate with the balance billing, then the provider can balance bill. So that effectively removes that claim from the protections of the balance billing, because the person's acknowledged and said, I'm willing to pay. But that also means that the provider can't then turn around and try and challenge or take those services into the negotiation or IDR process. At that point, it's settled. So neither the provider or the plan could pursue that through a negotiation once there's notice and consent.
Let's dive into the IDR process. Can you describe how the IDR entity is selected?
The party that is moving for IDR, the one that notifies the other party, as part of that submission, the information that they must sort of provide to the other party and to the government, they would essentially select or nominate a particular IDR entity, individual, and that information is going to be available through the portal. The other party would have to then either, accept or decline that individual as the IDR entity. But the parties have about 3 days, essentially. They have 3 days to figure this out, 3 business days. And if they don't settle upon a particular IDR entity, then CMS, HHS will make that determination. They'll pick. So once you hit day 4, HHS is going to say, okay, you guys, 2 times up, we're selecting, here's your IDR entity. And so you only have the opportunity to make that selection or, come to some agreement those first 3 days.
Great. And so just going into the decision process of the IDR process, what happens once the IDR entity is selected?
So the whole process is supposed to take 30 business days from the time the IDR entity is selected. At that point, the information that gets submitted by the party that's moving for IDR, it includes an offer. Both parties have to submit an offer, actually. And the process follows what's traditionally, technically known as baseball style arbitration, whereby the decision maker, the arbitrator, the only option they have is to select one of the parties' offers. They're not like coming to their own conclusion about what the appropriate amount is. They can't, split the difference. All they can do is choose one party's or the other party's proposed amount. And in doing that, the only thing the law requires them to consider, and, hearkening back to our discussion just a few minutes ago, is the qualifying payment amount. So they are looking to the median in-network contract rate to say whether the offer from the plan or the offer from the provider facility is the appropriate amount. And then there's certain types of information the IDR entity is allowed to consider. There's certain types of information they're prohibited from considering. And then there's a kind of a presumption that gets applied. And some of this comes from the law and some of this comes from the regs. So the law allows for consideration, again, optional consideration of information going to things like severity of illness of the patient, expertise or training of the provider, the nature of the facility. So is the facility kind of a specialty or a center of excellence? It goes to a bunch of different factors that the IDR entity can consider in determining, again, which offer is the right offer. So whether the provider's offer is the right one or the plan's offer is the right one. And then there are factors such as the billed charges, which they cannot consider, And also, they're not allowed to consider rates like Medicare, Medicaid, TRICARE, or other federal payment rates in determining, again, whether the offers are the appropriate offers. So the information, again, there's some they can consider, there's some they can't consider, but they must consider QPA, qualifying payment amount. What happened under the regulation is that HHS has directed the IDR entities to apply a presumption that the qualifying payment amount is the right number for payment, and that should drive their decision. So whichever offer is closer to the qualifying payment amount should be chosen, unless there is credible information submitted that's in those categories that can be considered, and that credible information shows that there is a significant a material difference in the amount that should be paid as compared to the qualifying payment amount. So there's kind of a high burden for kind of any of this information that comes in. First of all, you have to say it's credible. And then even if it's credible, it really has to show that there was a significant difference from what the qualifying payment amount is. So again, maybe you're showing that the severity of the patient was such that the services provided should be reimbursed at a higher level because it required so many more resources than what the qualifying payment amount would have taken into consideration in assessing kind of that average, that median network rate for the service, for example.
Thank you. And once the IDR entity makes their determination, what happens and what's the effect of their determination?
So there's a couple of things. The party that loses has to pay the costs. That's one thing that happens. At that point, there's a freeze that applies, which means that the parties involved, whoever moved for the IDR, whoever kind of initiated it, cannot initiate IDR between the same parties for those same or similar items and services. So they're kind of on a 90-day, and it is calendar day freeze, when they sort of everybody kind of go back to your corners and sit with this for a bit. If it's the provider or facility, they can hold on to those claims if in fact they've got additional claims that they may want to pursue, and then they can submit them for IDR at the end of the 90 days, but they have to hold them during those 90 days. The other thing that's interesting, they can also seek to batch claims if those are, again, between the same parties. So it's the same plan and the same provider, facility, provider group, et cetera, same or similar items or services. It can be in different market products. So it could be, large group plans, small group plans, as long as it's the same items and services between the same payers and payer and providers. And those can be heard together by the IDR entity, which could entail, and the departments recognize that there could be multiple QPAs that apply depending on, because that's calculated by market. So, for anything that was paid under large group plans, maybe one amount, and anything under individual market plans could be a different, a higher amount perhaps, but that's part of the process where you can do that as a batch.
Thanks, Helaine. So let's turn to the IDR entities now. Lesley, who are the IDR entities and how do they become IDR entities?
The IDR entities are private organizations that possess expertise in a whole variety of areas that will be important for being able to make the payment determinations that are going to be at issue through this dispute resolution process. So they have to be familiar with arbitration, claims administration, managed care, billing and coding. They have to have medical expertise. They have to have legal expertise. So they have to be well-versed in all of the different aspects that they'll need to consider when a dispute comes to them.
Great. And how do they become certified entities? What type of process is there?
Sure. So right now, and this started as of November 1st, there's an application process that the IDR entities must go through. And it's, essentially showing their qualifications in all of these areas. The application process is open on a rolling basis. So, it started November 1st, and we're seeing that applications are starting to come in by various entities, and presumably it will continue. We don't exactly know, how many IDR entities there will be. And so we'll have to wait and see as the rolling basis continues and new entities are able to be certified by CMS through this application process.
And how long does this certification last? And are there any requirements that the IDR entity has to meet in order to continue to be certified?
Yeah, so the certification lasts for 5 years, but there is a public process available for people to challenge the IDR entity's ability to serve as an IDR entity. So that challenge we're seeing can be done now as IDR entities are applying, and it can also be done once the IDR entities have been certified and are functioning. But some of the requirements that they will have to maintain in order to maintain their IDR entity status, assuming that nobody challenges them, they have to maintain current accreditation from a nationally recognized accreditation organization, or they have to ensure that their personnel possess the required training and expertise to conduct the payment determinations. They have to be able to show that they have policies and procedures in place related to conflict of interest, ensuring that decisions are made in an unbiased manner. They need to have experience with all different types of providers, facilities, air ambulance services. And again, as I mentioned, all of the expertise in billing and coding, some medical expertise. As Helaine had mentioned, they need to determine if the NSA applies to the claims. So they have to have some legal expertise as well. And they need to be able to maintain that and show that they're able to use that expertise in making decisions.
Great. Thanks for the overview of the IDR entities. We can turn to the external review process now. Under the Affordable Care Act, non-grandfathered group health plans and insurers must comply with state external review processes for certain adverse benefit determinations and final internal adverse benefit determinations that don't meet criteria for expedited review. Could you describe what adverse benefit determinations are?
Sure. I mean, essentially, it's a claims denial when the plan or the coverage has determined that medical necessity hasn't been met, that the service wasn't appropriate, it wasn't provided at the right healthcare setting, the level of care was inappropriate, or the service itself is, not considered effective as a covered benefit. So it's all the sort of claims denials that a plan could make for a particular item or service.
Great. And can you tell us about any requirements that the state has to meet for their external review process?
Sure. So the external review process itself, these requirements date back to the Affordable Care Act, and states have to implement an external review process that meets the consumer protections that were included in the NAIC's Model Act. They have to be binding on the plans or issuers, and if the state fails to meet those threshold requirements, then plans or issuers are required to use the federal external review process instead. That's conducted by a federal independent review organization or by HHS. These aren't new requirements, and the No Surprises Act did not add new requirements on the states, in terms of their underlying processes, but the No Surprises Act does require that these existing processes now need to apply to claims that come through the process that are related to the No Surprises Act.
Great. And could you expound on that a bit more about what that means as far as bringing those types of claims to external review and including that in the process?
Sure. Yeah. So again, it will be either state external review process, or if one does not exist, to go through a federal external review process. The No Surprises Act requires that adverse benefit determinations that involve considerations related to the NSA should be able to go through these processes, once a patient has either exhausted their internal coverage processes, or if there's no process available, that they go straight to the state or the federal process as a external review. And some of the things that we've seen examples that might be an adverse benefit determination related to the NSA that could go through the external review process would be, for example, if a plan decides that a pre-stabilization emergency treatment in an out-of-network emergency room doesn't actually qualify as an emergency service, right? They say it doesn't meet the definition, therefore the protections of the NSA don't apply. Then there could be greater cost sharing requirements that are applied to the patient. In that instance, the patient could bring that issue through the external review process. Or another area might be if the patient says that they did not actually give notice and consent to waive their protections under the NSA. And they say that, I didn't waive my protections against balance billing and I've, received a surprise bill, and therefore they can bring that to the external review process as well.
Great. Thank you. And I'll mention that goes into effect January 1st, 2022 also. And also, even though the bulk of the NSA will go into effect on January 1st, the government has either delayed or deferred several provisions through guidance and in response to stakeholder feedback. So in a recent frequently asked questions document, the government specified certain provisions of the NSA that will not go into effect on January 1st, and have also encouraged states who are the primary enforcers of some of the provisions of the NSA to follow the same approach. Helaine and Lesley, thank you again for your insight on this podcast sweep over the NSA's IDR process and changes to the external review procedures. As we bring this podcast to a close, I wanted to ask, in your opinion, what are some key issues you think stakeholders should consider as the effective date of the NSA approaches relative to the payment process, IDR process, external review, or any other NSA provision?
Providers and facilities, certainly, as well as plans and issuers, should be assessing their footprint, assessing their services on the facility provider side to have a sense or understand what's the scope, what's the application of the No Surprises Act versus state law. For example, a regional plan is going to have to look at the state laws in the states that they cover so that they can understand, and they hopefully have looked at this up to now, because if there are specified state laws, they have been in existence potentially, to understand what requirements the states apply to surprise billing, and probably start to get a sense of whether they think and what their counsel thinks as to whether the states that they're in have specified state laws. So is there a likelihood that those would control for the services that they apply to, and for, generally speaking, the fully insured market? Similarly, the providers and facilities should be doing a similar thing. If they're operating in a state, they should understand what that state's laws require, and then should be understanding and having a sense of whether or not those state laws would potentially be considered a specified state law. So are they going to need to meet the federal provisions or the states? And I think they need to start putting together a strategy for out-of-network bills, out-of-network services, to understand from the perspective of, a plan, a facility or provider probably doesn't want to go with their charges, what they've been traditionally charging. If those are just numbers that they don't anticipate getting paid, then, that may not be how they want to proceed. They may want to think about a strategy. Are they willing to pursue dispute resolution? Would they prefer to avoid dispute resolution? I think all these considerations should be taken into account in deciding what amount they should be billing for, and similarly on the plan side, what amount they should be paying as that initial payment, so that they are prepared. The timing is pretty tight. So once the plan gets the bill from the provider facility, there's not a lot of time to contemplate what your strategy is or start to formulate it. You need to make a payment within 30 days. Then the provider facility has 30 days to respond. It's going to be a quick turnaround, and you really should have this kind of laid out beforehand.
Great. Thanks, Helaine. And Lesley, any thoughts?
I think a big piece of the NSA is there's so much transparency and disclosure and communication that's required. So, in addition to what Helaine was saying about developing a strategy, I think it's really important for everybody to be thinking about, how are they going to put together the information that needs to be conveyed to all the various parties. The providers and facilities need to be interacting with their patients to let the patients know what's going on. And they need to be talking with the plans about what their charges are. And they need to be publicly posting information about their charges. And it all ties together with like going forward, how everybody needs to be sort of functioning differently under this new program. So that would be my takeaway, is sort of thinking through who everybody is sort of dealing with and interacting with, and how best to communicate all of the information that needs to be communicated in order to sort of solidify what your individual strategy is as a provider, facility, as a plan, and sort of hopefully smoothing the pathway forward as you're interacting with all of the different parties.
Great. Thanks again, Lesley and Helaine, and thanks to the listeners for tuning into this episode of Diagnosing Health Care. If you want more information about the NSA and its different provisions, or if you found this episode interesting, please look out for additional coverage on the NSA from Epstein, Becker, Green. To hear more on the interesting healthcare topics, or if you enjoyed today's podcast, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts.
Thank you for listening to Diagnosing Healthcare. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. The Employment Law This Week and Diagnosing Healthcare podcasts are presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of the legal services to be performed is greater than the quality of legal services performed by other lawyers.